Welcome to the Deep Dive. Today, we're getting into something pretty significant in the UK's legal history, the creation of the Supreme Court. Now, this wasn't just shuffling nameplates around. It represented a really profound shift, thinking about how justice is seen, where its power lies, especially here with our unwritten constitution. So our mission in this deep dive, we want to unpack the what, the why, and the how of this change back in 2009. We'll explore what it really meant and, the debate's still going on about its role. We've got some great sources to draw on. Okay, so the scene was set. Change was coming, but what actually happened? On the ground, October 2009.
Right.
Well, October 1st, 2009, that was the date. The House of Lords, which, believe it or not, had been the UK's highest court for centuries. It was officially replaced by a new body, the UK Supreme Court.
Not just a rebrand then.
No, absolutely not. It was really the end point of this long-standing constitutional peculiarity, something quite unique to the UK system. And let's be super clear for everyone listening, the House of Lords itself didn't disappear, did it? It's still the upper chamber of Parliament.
Precisely. Still very much exists in its legislative role.
It was just that its judicial function, that top court role, was carved out. Those 12 law lords who used to hear cases there, they moved over, became justices in the new Supreme Court.
Exactly. So that date, October 1st, 2009, it looks straightforward, but it really marks the end of an anachronism, you could say. This unique blending of the judicial and the legislative right at the very top. Well, this change was about sorting that out, bringing it more into line with, modern ideas about how government should be structured.
Which brings us neatly to the why. Why make this massive change? And it really comes down to this idea of the separation of powers. We all sort of get the basic concept, don't we? Legislative, executive, judicial. 3 branches. And the idea, which goes way back even to ancient Greece, is that you keep them separate, prevent too much power ending up in one place.
That's the ideal. Absolutely. You've got the legislature, parliament in the UK making the laws. Then the executive, that's the government, the civil service carrying them out, putting them into action. And then the judiciary, the courts interpreting the law, deciding disputes, figuring out what the law means in practice. Crucially, not making law.
But the UK system for ages had this anomaly, right?
Exactly. That's the perfect word for it. Before October 2009, the highest court, the law lords, they were literally part of the legislature, physically sat in the House of Lords, were members of it, which, when you think about that separation of powers principle, it just didn't fit. It looked wrong.
Yeah, it seemed like a clear breach of that principle. And people were pointing this out. I remember Lord Falconer, who was Lord Chancellor back in 2005. He put it very bluntly. He said the situation was, and I'm quoting here, no longer sustainable.
That's right.
He argued, it is surely not right that those responsible for interpreting the law should be able to have a hand in drafting it. Made sense.
It did. And he added, the time has come for the UK's highest court to move out from under the shadow of the legislature. Strong words.
And this wasn't just theoretical head-scratching, was it? There was a specific case that really highlighted the practical problem.
Yes. You're talking about Davidson v. Scottish Ministers 2. That was back in 2002. And it really laid bare the potential issues, the real-world consequences of blurring those lines.
What happened there? Remind us.
Well, essentially, a judge involved in the case, Lord Hardy, who was a former Lord Advocate, it turned out he'd actually spoken on the very issue being debated in court, but in a different capacity as a member of the Scottish Assembly, and he hadn't declared that.
So a potential conflict, or at least the appearance of one.
Exactly. The Scottish Court of Session, which is like the Court of Appeal up there, they ordered a retrial. Their reasoning was that there was a real possibility of bias, because he hadn't mentioned his prior involvement.
So it really underscored the point. Even if there was an actual bias, the appearance of bias was damaging enough when you had judges who were also involved in the legislative or political side of things.
Precisely. It added real weight to Lord Falconer's argument that things had to change.
Okay, so we've got the creation of the Supreme Court, separating it from the House of Lords, and why fixing that separation of powers anomaly highlighted by cases like Davidson. So then, the how. How did this enormous historical change, as you called it, actually happen? What was the mechanism?
The key piece of legislation was the Constitutional Reform Act 2005. Specifically, Part 2 of that act. That's what laid the groundwork. It did several crucial things.
Right.
First, and most obviously, it formally established the new independent Supreme Court. Separate building, separate staff, its own budget, its own appointment system, completely distinct from the House of Lords.
And they moved into Middlesex Guildhall, right, opposite Parliament Square.
That's the one, a very symbolic location, but crucially a separate one.
And you mentioned something earlier, just a point of clarification needed here. This new Supreme Court shouldn't be confused with what used to be called the Supreme Court, right?
Yes, good point. It does cause confusion sometimes. Before this act, the collective name for the High Court and the Court of Appeal was technically the Supreme Court of Judicature. That older structure is now called the Senior Courts of England and Wales. This new Supreme Court, established in 2009, is entirely different. It's the apex court, the final court of appeal.
Got it. So senior courts, and then above them, the UK Supreme Court. What else did the 2005 Act do?
Well, secondly, it addressed the judges themselves. The 12 law lords became justices of the Supreme Court. That's their title now. And critically, they're no longer allowed to sit or vote in the House of Lords while they're serving justices.
So a proper separation of personnel, too.
Yes. Although an interesting point, because they were appointed as life peers originally, they can actually return to sit in the Lords after they retire from the court.
Ah, okay. And who were the first justices? Were they just the existing law lords?
Pretty much, yes. It was designed for continuity. 11 of the 12 sitting law lords, or lords of appeal in ordinary as they were formerly known, took up positions as the first justices.
Only 11. Who was the 12th?
Lord Newburgh. He was one of the 12, but instead of moving to the Supreme Court, he became Master of the Rolls, which is the head of the civil division of the Court of Appeal.
I see. And the first president?
That was Lord Phillips. He'd been the Lord Chief Justice, the head of the judiciary in England and Wales, and he stepped up to be the first president of the new Supreme Court.
Right. So a new court, new titles, new building. Seems like a complete overhaul. But, and this is really important, isn't it? There's something the UK Supreme Court isn't.
Absolutely crucial distinction to make, especially if you're comparing it to, say, the U.S. Supreme Court or courts in Germany or France.
It's not a constitutional court in the same way.
Exactly. It does not have the power to strike down acts of parliament, to declare primary legislation invalid or unconstitutional. This goes right back to that bedrock principle of the UK Constitution,
Sure.
Parliamentary sovereignty.
Explain that for us again.
Simply put, Parliament is the ultimate source of law in the UK. What Parliament enacts as law is the law. The courts can interpret it, apply it, but they cannot override it. They can't say, sorry, Parliament, this law you passed is incompatible with the Constitution, so it's struck down.
Even with the Human Rights Act, that brought the European Convention on Human Rights into UK law. Didn't that give courts more power?
It gave them a new tool, yes, but it was very carefully designed not to challenge parliamentary sovereignty. Under the Human Rights Act, if a higher court finds an act of parliament conflicts with a convention right, it can issue something called a declaration of incompatibility.
A declaration, so it's like flagging an issue.
Precisely. It's the court saying to Parliament, look, we think this law you passed doesn't square with human rights obligations. But crucially, the law remains valid. The declaration doesn't invalidate it.
It's then up to Parliament to decide whether to change the law or not.
Exactly. Yeah. Parliament retains the final say. So the Human Rights Act works within the principle of parliamentary sovereignty. It doesn't override it.
So this big 2009 change, it definitely increased the appearance of separation of powers, a separate building, separate judges.
Yes, the symbolism was hugely important. It looks much more like a distinct judicial branch.
But the fundamental power balance, especially Parliament's ultimate lawmaking authority, that remained untouched.
That's the key takeaway. Structurally different, visually separate, but the core constitutional doctrine held firm.
Okay, so moving on from the structure and the powers it doesn't have, what about the future? When this court was set up, was the idea just for it to carry on doing exactly what the law lords did, just in a different building?
Well, that was the big question, wasn't it? Would it just be business as usual, or would this new, distinct, visibly independent court start to behave differently, maybe become a bit more assertive?
Like Supreme Courts in other countries often are.
Potentially. And opinions back in 2009 were really quite divided on this, even amongst top judges.
Oh, really? Who had what view?
Well, you had Lord Newburgh, for example. Remember, he became Master of the Rolls instead of joining the new court. He gave an interview on BBC Radio around that time. And he expressed quite a lot of caution. He said something like, the danger is that you muck around with a constitution like the British Constitution at your peril.
Because you don't know the unintended consequences.
Exactly. He worried it might upset the delicate balance. And he specifically warned there was a real risk of judges arrogating to themselves greater power than they have at the moment. Essentially, judicial overreach.
Wow. So real concern from a very senior figure about judges potentially grabbing more power.
Yes. But then you had others, like Lord Falconer, the architect of the reforms.
He obviously had a different take.
Completely different. He was much more optimistic, or perhaps radical, depending on your view. He believed the Supreme Court would actually be bolder in protecting individual freedoms and also significantly being willing to take on the government. He saw it becoming a stronger check on state power.
Two very different predictions there. What about the first president, Lord Phillips? Where did he stand?
He struck a more conciliatory note, perhaps. He didn't seem to anticipate the court changing quite as dramatically as Lord Newburgh feared. His view seemed to be more towards continuity, suggesting it wouldn't necessarily lead to judges trying to expand their powers significantly, more of a gradual evolution.
So a spectrum of views right from the start. And for law students or people involved in cases at the time, did it make a huge practical difference day to day?
Initially, no. And that was the intention. The government stressed it should be a seamless and unproblematic transition. The decisions and precedents set by the House of Lords remained binding on lower courts, just as they were before. The rules for appealing cases, the procedures, they largely continued.
So the legal substance didn't change overnight. It was more about the structure, the symbolism, and maybe the potential for future change.
Precisely. The immediate impact was more constitutional and presentational than affecting the content of the law itself.
Okay, so let's try and wrap this up. This deep dive has shown us that the UK Supreme Court's creation in 2009 was, well, a landmark moment. It clearly marked a big step towards a more visible separation of powers. Sorting out that historical oddity in the UK's setup definitely felt like a modernization.
Yes, it tidied up the constitutional architecture.
Yeah.
But, and it's a crucial but we've kept coming back to, this reform was much more about that symbolic and structural independence for the judiciary, making justice seen to be separate. It wasn't about giving the court new powers to strike down laws. Parliamentary sovereignty, that core principle, remains intact.
Right. The appearance changed significantly, but the fundamental power didn't necessarily shift in the way it might have in other systems. Which leaves us with a really interesting thought, doesn't it? Given those differing views right at the start, Newburgh's caution, Falconer's boldness, and given the UK's unique, evolving, unwritten constitution, how might just the appearance of greater separation, that visual independence, subtly change things over time? Could it influence how the public sees the court? Could it gradually alter the dynamic between the judges, parliament, and the government, even if the legal rule of parliamentary sovereignty hasn't changed on paper?
It's a fascinating question. Does perception shape reality in constitutional terms?
Exactly. How important is the perception of justice? And what does this whole story tell you, our listeners, about those often unseen forces, the historical quirks and deliberate reforms that shape how law and power actually work in a country? Something to think about.